Good morning, Your Honor. May it please the Court. Kevin Colbert on behalf of AH, the mother. I'd like to reserve 2 minutes to rebuttal, please. Your Honors, we're here again for an oral argument because the facts in the record in this case are not sufficient to support a termination of parental rights under 39806(1)C, which is irrespective of services, or 39806(1)F, which is egregious conduct. This mother did not take all the steps that were required of her to protect her children because she had a mentally ill father involved. However, she did call the police numerous times. She did remove the children from the home, both of which were in her domestic violence plan, which was call the police or flee. She made efforts to move the apartment to a building that had 24-hour security so that the father couldn't continue to harass them. And finally, she got passports and was going to move the children to Jamaica. I would argue to the Court that her conduct under 39806(1)F does not reach the standard, which is outrageous, flagrant, or deplorable. This mother may not have taken all the steps required of her, but she did protect her children, and she did take numerous steps. Now, the Court was so good as to provide us with MM out of the 4th DCA. And it is very analogous to this case. Both in MM and in here, the children were not exposed to domestic violence. From the time this case was an expedited TPR, it ran from the time the children were returned to the mother in October of 2009 to February of 2010 when they were removed.
Wait, did you say that the children in this case were not exposed to domestic violence?
That's correct, Your Honor.
Are you suggesting that this evidence taken in the light most favorable to DCF does not show that the children were exposed to domestic violence?
In that time frame, Your Honor.
Which time frame? You're talking about after the reunification?
Yeah, correct, Your Honor. Because this case was tried once before in a termination of parental rights, and it was denied.
You're talking about 09 to 10. You're talking about the 14 months.
Correct, Your Honor. From the time of the denial of the termination of parental rights to the time these children were removed. This was an expedited TPR. This was not brought on a 39806(1)E, 1 or 2, which is failure to comply with the case plan. This was brought on an expedited basis when the case came back in for those 2 grounds, that irrespective of services, the children would continue to be threatened with harm, and that the mother had committed egregious conduct by allowing the father to continually have contact with these children.
Wasn't there a domestic violence incident in February of 2010 in which the father poured hot soup on one of the children?
No, it wasn't hot soup. First of all, it was
cold. Was it soup?
It was soup, yes.
Oh, okay.
It was cold soup.
How do we know it was cold soup?
The child testified to that.
Oh, okay.
The child, RL, testified that the soup, in fact, on my cross-examination, he testified that the soup was not hot, it was cold.
And this was within a week after the father was released from jail following a prior domestic violence incident which had occurred subsequent to the reunification of the mother and the children, right?
If I could correct you, Judge, actually there were no domestic violence incidents. The father kept going to jail for his violation of the stay-away order that was entered by the trial court. He never committed any...
So it was a violation of the domestic violence injunction.
Yeah, exactly. The original domestic violence occurred in the year of 2006.
Right.
That is the only domestic violence that occurred.
And the mother admitted that after the reunification of her and the children, and after the father was released from custody in 2010, she allowed him to come back into the home. Is that right?
Allowed might not be the correct word, Your Honor. She continually tried to remove him. She continually removed herself. She called the police 4 times on him in that time period between 2014 months that Judge Salter was talking about.
2009 through 10?
Through 10, she
In
called.
which there were 29 complaints made to the police.
And 4 of them were her calls where she either called or went to the police. And I believe the court is incorrect in saying he was in jail for a week. What happened is...
I didn't say it was... I said that she allowed him to come back to the home within a week of his release.
Okay, my error. I misstated.
I don't know how long he was there.
I believe the testimony by the mother was, and the children, that he would be gone for 1 day. He'd get arrested and he'd come right back.
And are you suggesting that the court had to accept her testimony that she didn't want him in the house?
Both the children testified equally. Both of them said that their mother continually removed him from the home, that the mother called the police, and that the mother told him to leave.
Did the children also testify that the mother made the children lie about the father being in the house?
The 5-year-old said that the mother said that. The 12-year-old denied it.
So what if the court were to find more credible the 5-year-old's testimony as opposed to the 12-year-old's testimony? And wouldn't we assume, if we are giving all reasonable inferences to uphold the court's decision, that the court found the 5-year-old more credible, at least in that instance? Why would we not?
I can't argue with that at all.
So you're suggesting that the court should not be able to take into consideration the fact or that the mother lied during this reunification, during the case plan period?
I don't know if lies is necessarily the word, Your Honor, but she certainly didn't advise the court nor anybody in the DCF nor anybody in the Guardian that lied on that the father was continuing to harass her. She took her own steps.
Continuing to come to the house. Your characterization of harassment is one for the court to make, right?
Okay. She continually came to the house over her objection. Again, that both children testified that she asked him to leave. Both children testified, as did she, that she went to the police. Nothing she did seemed to work. And she testified without contradiction that she was afraid they were going to remove the children again if they found out he was coming around. Be that as it may, a demurrer would be, assuming that the 5-year-old was the one the court relied on, it still doesn't rise to the level of deplorable and flagrant conduct for a determination under...
Well, that's not the... I have no doubt personally that is correct. But the other one is the failure to abide by the case plan. The other basis for termination.
She substantially complied and the case was closed. That was not a ground in this termination of parental right. The only 2 grounds that were alleged or tried in this case were 1C and 1F. 1F being egregious conduct and 1C being irrespective of services. Irrespective of services requires that they have 2 prongs. That the continued interaction threatens the life, safety, and health of the children. And I would argue to the court we don't even get to the second prong because the mother's continuing interaction with these children does not threaten their health, life, or safety.
Unless she allows the father to continue to come by and visit. And of course, it's a difference of characterization.
I take exception to your characterization of allowed, but yes, you're absolutely correct.
She continues to deny the stabbing incident?
No.
She did not continue to deny the stabbing incident?
No, Your Honor, she did not. That was a problem early on in the case before her original reunification. But she went to therapy with Dr. Brody, and in fact her testimony was it was during her therapy with Dr. Brody that she came to realize that the father had a mental health problem. Just like in MM, it was something that came to her during the case, not something that she knew before, something that occurred over a period of time.
So is it a question of whether the court was correct or incorrect in its conclusion that the mother did not have adequate insight into the problems and the issues and thus could not protect her children? Is that the issue?
No, I think that what the issue is whether or not her continued interaction with the children threatens them with harm. And again, nobody testified this mother is incapable of taking care of these children in any way. There's a close bond between the children and the mother. She took excellent care of these children. The eldest child's in advanced courses according to his own testimony. What I would argue to the court was the only problem here is an outside factor, which is the father. And he's unlike the father in MM. In MM, the father complies when the mother tells him to stay away. Here we have a mentally ill individual who she tries to get help from by her own testimony, and who every time the police arrest him, they turn around and put him back on the street so that he can reoffend. I find it interesting that
part of the reason is because she would not go to court to testify in those cases against him, right? On at least 2 occasions, she failed to appear in a prosecution either for an injunction or for violence committed upon her directly. She did not show up to court or fail to prosecute.
I don't believe there's substantial and competent evidence of that, Your Honor. And moreover, I would point out in MM, the mother there failed to continue on her temporary restraining order to get a permanent restraining order, which would not be dissimilar. And this was a dependency case, MM. They couldn't find enough evidence in a very similar case to have a dependency, let alone a termination of parental rights, which is the death penalty of these cases. This is the end.
Is there any record evidence that the father's been deported to Jamaica?
None.
There is no record evidence of that?
What I was going to suggest to the court, I also find it very interesting that only after these children removed and DCF get involved does the father stay in jail. She had him arrested 4 different times previously for the very same charge, and he gets released a day later. And only after her children are removed this last time does he end up in jail on criminal charges. And that's where he is today.
The significance being, I'm not sure I followed.
I think the system failed her, Your Honor. I think the system failed her where she continually called the police and nothing was done. The state's attorney didn't prosecute. The police didn't hold him in jail.
No good deed goes unpunished.
That's absolutely true, Your Honor. And for those reasons, Your Honor, I would ask the court to reverse this final judgment of termination of parental rights.
Thank you. From TCF. The guardian ad litem.
Yes. Good morning, Your Honor. Hillary Kambour for the guardian ad litem and Karla Perkins for the Department of Children and Families. The children there was evidence, competent, substantial evidence, these children were harmed.
Is the court entitled to look at the 6-year history, or as your adversary suggests, should it be limited to the 14-month duration of the proceeding?
Well, I think that it primarily needs to focus on the 14 months.
What case do you rely on to support the judgment? That the failure to protect from somebody else's misconduct terminates your own parental rights?
Your Honor, the ground upon which 806
Can you give me a case?
Well, the cases that I cite, Your Honor, talk about parents who have a problem, who get services to fix that problem, and who continue to engage in the behavior. And those cases are all cited on page 18.
Do you have any case in which the parent in question, whose rights are being terminated, has done nothing wrong herself?
Well, Your Honor, the nature of domestic violence...
Do you have any case?
I do not have a case that says what Your Honor is asking me, specifically is asking me. The nature of domestic violence problems in dependency is that the victim, one of the victims, that being the mother in this case, has an obligation, despite her status as a victim, to protect her children.
Of course she does. Of course she does. But what justifies her the termination of her rights if she doesn't do a good job of that?
Because the children are in danger.
What justifies under the law?
Because the children remain at risk.
But you have to do something wrong yourself to be punished.
Your Honor, in this case, it's not punishment.
You don't lose your parental rights vicariously.
Well, especially if you're talking about intentional criminal acts.
Right, and that's not what we're talking about here.
So is there evidence at this hearing, not going back during the 6-year plan, where it's clear that she either lied or failed to represent properly what was going on, but at this hearing, is there evidence that she allowed the father, that she was complicit in him coming back to the home?
Your Honor, she was serving him soup the night that the incident that brought the children in. I'm not denying that she made efforts to keep him out of his life, and clearly this is a very difficult problem. She did have him arrested. She did attempt to move.
How can, on the basis that she made efforts and they weren't good enough, terminate her parental rights? What is the most extreme case? Because this, in my opinion, is extremely extreme. What is the most extreme case that you have that justifies termination of parental rights on remotely similar facts?
Your Honor, I don't have that case before you. We don't have a domestic violence case.
What about MN, in which there is not even a dependency finding?
Right.
In fact, there was a dependency finding and it was reversed.
Right. In MN, there's no evidence of harm. There's undisputed evidence these children were significantly harmed.
But they were harmed by somebody else. They were harmed by the father. They weren't harmed by the mother.
Right. But this court in DR and other cases have said that when a parent permits that harm to continue, then they are responsible, and that's the point. As a parent, you're responsible to protect your children. The obvious answer would have been for this mother, who had an ongoing and positive relationship both with her case manager and her individual therapist, was to ask for the help. She needed help.
And that was wrong. The obvious answer. Everybody says that. The question is, how wrong was it that she lose her children because he didn't communicate with the caseworker.
What were the other options that the court had available to it short of terminating her parental rights?
That is an excellent question, Your Honor, and I think that's the problem. We have 3 years. This case came in 2006. The legislature says we have a year for permanency, and we are 3-4 times that at this point. She got all of these services. She went to domestic violence. She was supposed to learn that at all costs she had to.
The answer is to dismiss the case, and she has her children.
The court found that there was
the idea is to end the case no matter how.
The idea is to find permanent safe places for these children, Your Honor.
The problem is balancing her parental rights against the child's right to be protected when with the mother.
Exactly right.
And how far does the state intercede when those things don't happen?
Right. And under 8061C, when you have given that parent services to correct the problem that endangered her children, and she took those services and completed those services, and then continues after 3 years to permit the same harm to afflict her children.
Why not give her those services again?
Because that is now 4 times the statutory mandate for 1 year to permanency.
But why not give them to her when, on balance, what you're asking us to do is to affirm the severance forever of her right to be with her children?
I understand. Because of the significant harm these children suffered while in her care, because of the domestic violence, harm that Dr. D. Tomaso testified the trial court hadn't heard such significant harm before. She'd heard him testify many times. In this way, this harm was, he testified possibly irreparable.
What harm?
Harm of exposure to violence, Your Honor, in your home.
But whose violence?
After interviewing the kids, he referred to rampant violence in the home, and all of the children were harmed by that violence.
Exactly right.
And he thought one of them was lost, in fact, already, psychologically.
Possibly irreparably. And that was the evidence that compelled the trial court, I believe, in this case. Your Honor, I have no other questions. We'd ask that the trial court were to be approached.
Thank you. Rebuttal?
Your Honor, I would suggest to Judge Emas that even had DCF been involved, it wouldn't have made a big difference with his father. He's mentally ill. He was arrested and released. He continued to come back. Even when he was arrested by the police, I don't know that anything that DCF could have done. Admittedly, his mother should have reached out to DCF, but she was afraid they were going to take her children like they had the time before, and she didn't do it. But she did make efforts to protect these children. But even had DCF and the guardian been involved, what would they have done that she didn't do? Get him arrested again because he continually was released by the police. That was out of her control, and that would have been out of DCF's control. I would also argue that the harm that Dr. D. Tomaso testified to is unsupported by the evidence in the record. He testified that these children were exposed to continuing violence. Both children said there had been no violence in the home, explicitly by R.L., who testified on cross-examination. Did your father ever hit you or anybody? And he said no. And that was at 195, I believe it is, Your Honor. And he asked, and it's the same with D.L., who was asked about his father's temperament in the home, and he said he got mad one time when they kept asking him for a skateboard. These children were not exposed by the mother for that time period when they were returned in the home to any domestic violence. Again, Judge Emas, those were violations of the permanent restraint of the stay-away order that he was arrested for, not any continuing violence. The only violence in the record is the stabbing in 2006, and R.L. testifies that he remembers his father hitting his mother when he was 3 or 4 years old. This is a 12, almost 13-year-old testifying. There was no ongoing domestic violence. The problem here was the father would not go away, and the mother took positive steps to rectify that. And I, again, ask this court to deny the final judgment termination and reverse.
All right. Thank you very much.